Hello everyone, welcome to this class, our online series of lectures during this pandemic. Once again, my name is Sostin Ngabirano and I'll be taking you through the law of contract. In our previous class, we looked at the law of contract formation, specifically the element of an offer. And now today, we wish to build onto that and look at the second element of a valid contract, which is called acceptance. Like I said in our previous lecture, that when there is an offer, for you to talk about any consensus addendum, there must be some sort of acceptance. So in this class, we are going to look at specifically acceptance, and we shall keep building onto that as we proceed during the course of the semester. So welcome once again. I'll be taking you through this, and you can also take note of the slides, and other materials can be accessed on our learning platform, which we advise to go and always check. All updates are uploaded there, so please make sure that you always go and check the platform, and remember to attend our online classes or the interactive discussions on Saturdays and Friday every week. So today I want us to look at acceptance, and in the first place I would want to start with a question: what is acceptance? So acceptance has been defined as unqualified assent to the terms of an offer, and I think I mentioned this yesterday in our class, the recording of which you can also access on my YouTube channel. Acceptance, like I've said, is unqualified assent to the terms of an offer. So the moment there is any deviation from the terms of a given offer, then that doesn't become acceptance. And recall yesterday we looked at a counter offer. So the moment you change the dynamics of my offer, then it may become something different, and that will be a counter offer. And a counter offer negates the original offer, meaning that you're on different terms altogether. So in this slide, I've provided for you the key provisions of the Contract Act 2010 that you need to master when you're looking at this particular topic of acceptance. The first one is section 2, which defines what acceptance is, and I've done that already. Then I would also invite you to look at section 3.2, which talks about communication of acceptance, and this is very key because, as you're going to see in the foregoing discussion, that communication of acceptance has a lot of significance in contract formation. Then completion, I also invite you to look at section 4.2a of the Act, and section 7. Most of these sections are looking at the communication, basically that the rules governing acceptance and how you move forward. The good thing is we are going to look at these rules as we go forward during this particular lecture. Yes. So for an acceptance to be valid, there are certain things that must be fulfilled. So for an acceptance to be valid, it must be made while the offer is still in force. Remember yesterday we talked about an offer being revoked before acceptance. So there can't be acceptance unless the offer is still in force. Then the acceptance must be made by the offeree, and it must match the terms of the offer. This I've talked about it, so I won't emphasize it again, because if it doesn't match, then it becomes qualified, and that makes it a counter offer. Then this acceptance may be written, oral, or implied from conduct. You recall what we talked about under Khalil versus Kabul Smoke Ball Company, that landmark case, which I invited you to read. Under that case, acceptance was by conduct. So acceptance may be by conduct, and in certain cases a party to a contract may require that acceptance be made in a certain way, and therefore for such a contract to be, rather for such acceptance to be valid, then you must follow the prescribed mode of acceptance by the offerer. You have to take note of that, that where there is a stipulation that acceptance shall be by a certain mode, then you must strictly follow the accepted mode of, or the stipulated mode of acceptance. Now let's move on and look at communication of acceptance. You see, I've already said that one, if you have intentions, sometimes I jokingly tell people that imagine you see you are in a class, you're all young students, you've just joined the university, and you're in this stage, you want to make a relationship, and you have intentions. So you must make your intentions clear, and the only way you can make intentions clear is via communication. So without communication, you cannot talk about acceptance. So acceptance must be communicated in one way or the other. How? If you want the details on how communication of acceptance is done, please look at section 4 of the Contract Act. But most of them, we shall look at them in the course of the lecture. But section 4 is very instructive. So acceptance must be communicated by the offeree or his agent, because it must be communicated by someone with authority, either the offeree or someone who is authorized to act on behalf of the offeree. And there is an old case of Powell versus Lee, and in that case, an unauthorized communication by one of the managers, that the board of managers had selected a particular candidate for a headship job, was held known to be valid acceptance because the communicator or the manager who communicated did not have the authority. He wasn't authorized. So you, the offeree or your agent, can communicate, this acceptance. And the communication of an offer may be made by an act or omission of a party who accepts the offer, by which that party intends to communicate the acceptance, or which has the effect of communicating the acceptance. That is in the words of section 3.2 of the Act, which I had tried to summarize up there, saying that acceptance must be communicated by the offeree or his or her agent. So the key points to take home is that the communication must be communicated. Rather, the communication of acceptance must be done by either the offeree or his or her agent. So now I've talked about communication. Therefore, I want us to look at this slide very critically. It is headed silence as a communication. Can silence be communication? You zip your mouth. No, I won't say anything. Can that amount to effective communication of acceptance? I don't know, you will tell me. But there is a decision, very old decision, but it's a locus on this matter, called Feldhaus versus Bindley. And in that case, a plaintiff wrote to his nephew offering to buy a horse. And in that letter, the plaintiff added the words, "If I hear no more, I will take it that the horse is mine." Okay? The nephew did not reply to this letter. Of course, a suit ensued, rather there was a dispute ensued, and it went to court. The court held that no contract had been formed because acceptance had not been communicated to the offerer. Okay? So that's why communication is very important. So the general rule is, the general rule is that silence can never amount to acceptance. And I asked a question down there whether can silence ever amount to acceptance. Does it mean that by the above authority, silence can never amount to acceptance? For example, if we take the example of the case I've just highlighted above, Feldhouse versus Bindley, where the offeree, what if the offeree had relied on the offerer's statement that he need not to communicate his acceptance and wished to claim acceptance on that basis? Could the court decide that the need for acceptance had been waived by the offerer? That's food for thought. I want you to think about it. What if there was a flip of the facts in Feldhouse versus Bindley and the requirement to communicate acceptance had been requested for or waived by the offerer? Would that be effective acceptance? You can have a discussion on that, and I look forward to discussing this with you in greater details when we meet in our live classes during the course of the week. Please keep your questions when you watch this video. Keep your questions down. Like I said, you can contact me via my official email, or you can send me a WhatsApp message on 0782 000 404, and I'll gladly respond to your inquiry. Let's proceed and now look at the exceptions to the rule that acceptance must be communicated. You may have noted that, like I said, that the general rule is acceptance must be communicated. But in some cases, there are cases where you need not to communicate acceptance, and we've looked at some of them. And the first one is in cases where the contract is unilateral in nature. We looked at the case of Khalil versus Carbolic Smoke Ball Company Limited, where I gave an elaborate example of even if we had tried to link it to the current COVID pandemic, that if someone sends out an advert and the advert stipulates conditions, when you perform or fulfill those conditions, then you're deemed to have accepted the given offer. And in that case, there is no need to communicate, to communicate your acceptance. That's exactly what happened in Khalil versus Carbolic Smoke Ball. It has also been suggested that possibly where the failure of communication is the fault of the offerer. This was suggested by Lord Denning in the case of Enterprise Limited versus Miles Far East Corporation, a 1955 authority, which I will invite you to read, that sometimes the failure to communicate may be due to the fault by the offerer, that that requirement may be waived. Then lastly, on these exceptions, there is one important one where you decide that your mode of communication shall be by way of post. A post. I know many of you are young, at least my students watching this video. You may not have seen the days when we are using post office to communicate. These days you communicate via WhatsApp, via email, and these modern means. There are so many, and many others. Telegram, I've seen all that. But where you use post office, and post is deemed to be a proper method of communication, and there are case authorities that have dealt with this particular aspect. In the famous case of Adam versus Lindsay, the defendant wrote to the plaintiff offering to sell them a quantity of wood and requesting acceptance by post. So the plaintiff immediately posted an acceptance on 5th December, and court held in that case that the contract was concluded on the 5th day of December. I will invite you to look at, I think it's section 4, communication of acceptance, which says that acceptance is deemed to be complete when the offeree has set in motion the mode of acceptance, or when the offeree has posted the letter, and at that point he cannot retract it. So when you go to the post office and you buy those stamps, and then you post the stamps by having them stamped, and then you hand over your letter to the postman, then acceptance is deemed to be complete at that stage. And by virtue of that discussion, I think it would be incumbent for us now to consider this postal rule. What is the postal rule? Why the postal rule? Why was it, why do we have this postal rule in the first place? So, under the postal rule, which is an exception to communication of acceptance, acceptance takes place when a letter is posted, not when it is received. See section 4.2a of the Contract Act. I've tried to throw some light on that, but you'll have to go and read it. And of course, that case of Adam versus Linsell. So, acceptance is effective on posting even where the letter is lost in the post office. So, in Household Fire Insurance Company Limited versus Grant, that case, the defendant offered to buy shares in the plaintiff company. So a letter of allotment was posted to the defendant, but it never reached him. Court held that the contract was completed when the letter was posted. Of course, it looks a bit, unfair, but the rationale is, like I told you, that the moment someone chooses post as a mode of communication, then they have no control on what happens in the post office. So the moment they post their letter, they have done what is required of them on their part. So that is briefly about the postal rule. But I want you to note one key difference. And this is very, very important. Students always fail to note this. The difference between acceptance and revocation of an offer by post. So acceptance of an offer takes place when the letter is posted. However, revocation of an offer takes place when the letter is received. So, for revocation, the rule of posting does not apply. Okay? Please note, the rule of posting does not apply when you're revoking an offer. It only applies when you're accepting. And there is a case there that you read, it's reported in so many textbooks. It's called Van versus Van Tienhoven, very old authority, 1880. It's an English authority on that particular concept. So that is it, about the postal rule, the general postal rule, but it equally has certain limitations. What are these limitations to the postal rule? One, I have already mentioned this, that it only applies to acceptance and not to any other type of communication. For example, an offer or revocation. So acceptance, postal rule only applies to acceptance. Two, it only applies to letters and telegrams. It does not apply to instantaneous means of communication such as telex, probably fax or email or even WhatsApp, where you can scan and send someone a document. That the postal rule does not apply. So today, if we concluded an agreement and you had to, I gave you an offer and you had to reply to me, let me say via WhatsApp, and you get your phone, scan a document using some of those scanning apps, and you send it to my email, or you send it to my registered WhatsApp line, there is no acceptance at sending. So there are different rules that govern what we call instantaneous means of communication, like I've noted. So lastly, the limitation, it must be reasonable to use the post as a means of communication. For example, an offer by telegram or by fax may indicate that a rapid method of response was required. So letters of acceptance must be properly addressed and stamped this rule is the rule on acceptance may be easily displaced. For example, it may be excluded by an offerer either expressly or impliedly, like it was in that case of Howell Securities Limited versus Hughes. So for the postal rule to apply, one other limitation is that the letter must be properly addressed. Never mind that if it gets lost, still the rule applies. But if it wasn't properly addressed, it means in the first place it wouldn't have reached its recipient. So the letter must be properly addressed for the rule to apply. That's another limitation. So there I've talked about instantaneous means of communication or electronic means, and I would wish us to look at that now. So the rules on telephone and telex were laid down in that case of Ventures versus Farmiles East Corporations and confirmed in Brickbone Limited versus Starhill in 1983 decision, where it was suggested that during normal office hours, acceptance takes place when the message is printed out, not when it is read. And the House of Lords, however, accepted that communication by telex may not always be instantaneous, for example, when received at night or when the office is closed. And Lord Wilberforce stated that, and I quote, "No universal rule could cover all cases. They must be resolved by reference to the intention of the parties, by sound business practice, and in some cases by judgment of where the risk should lie." So, and I will pose a question based on that authority, which I will invite you to read in greater details. The citations are on your reading list. What do you think would be the status of an email communication? Remember, email is instant. Would the contract or the offer be accepted upon receipt of an email? What about you sending me a WhatsApp communication? You know WhatsApp, when you send a WhatsApp, it is received with 2 black ticks. And when I read it, it gives you the blue ticks. Although because of privacy reasons, some of those functionalities can also be disabled. So at what point would a WhatsApp message be considered effective acceptance? If it's WhatsApp, or what if it's an email? When will it be acceptance? Okay, I want you to look into that, and I will refer you to one good book called Contract Law Text, Cases and Materials, and that book is by a famous professor, Ewan McKendrick. That book, when you look at the, I think it's chapter 1 on acceptance, specifically on instantaneous communication, the specific pages are on your reading list, and you can get them. There is a commentary on instantaneous means, and it should be able to help you answer the questions that I just posed behind there. In summary, as I conclude, I want you to note that for an offer must be accepted for us to have a consensus ad idem. And because of acceptance, communication is very key. Communication of an offer, and without communication, you can't talk about acceptance. So you need to look at those rules governing acceptance. This is a very short topic. You have about 5 or so sections under the Contract Act that you need to internalize and understand. It's very short but very crucial to your understanding of the law of contract, specifically formation of contract. So you need to understand it, and I think I want to stop here today, and I look forward to meeting you in our next online session next week. We shall have our live discussion on Friday and Saturday. So please review this, watch this video, look at the slides, watch other videos which are available on other YouTube channels, but you can always come and visit my YouTube channel, get to learn about the law of contract, and like and share these videos for other people to also benefit. Let me thank you for watching, and I look forward to meeting you. Please stay safe and see you soon. Bye bye.